Good afternoon. Welcome to today's panel presentation on the new book, The Constitution in 2020. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. For those of you who aren't familiar with ACS, it's a national network of lawyers, academics, policymakers, and law students that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. Through the generosity of the Open Society Institute, we are pleased to bring you today's panel and to be able to provide you each with a complimentary copy of the Constitution in 2020. This event comes midway into a project that began several years ago as scholars, lawyers, and students started to organize in an effort to re-examine the Constitution and the process of its interpretation. One of the key events that kicked off this effort was a conference held at Yale Law School 4 years ago with the editors of this book, the 22 scholars who wrote essays for the book, and the scores of others who were deeply concerned that conservatives had hijacked our understanding of constitutional interpretation through repeated and methodical, although ultimately meaningless, promotion of concepts like strict construction and original intent. We recognized that we needed to organize and begin a discussion that would shed light on how the Constitution should be interpreted to fully vindicate the principles and values that the founders embodied in this great document. Significant progress has been made in realizing these principles and values over the past 200 years, but we still obviously have a ways to go, and we will always need to take account of developments and changes in our country and in the world around us. These scholars set out to describe the process of interpreting the Constitution in addition to the direction they anticipated the Constitution and laws could and should develop in the years ahead with regard to such critical things as our understanding of citizenship, the engagement of the people in the process, the meaning of our rights and liberties, and America's place in the world. So we are thrilled to bring you today's outstanding panel. With the publication of this book, we have captured in one place key portions of the discussion over the past few years. And with today's panel, we look forward to starting the next phase of our project by promoting many fruitful discussions and debates that we hope will engage our contemporaries and future generations in finding ways to restore the best of our constitutional traditions that have been ignored or harmed in recent years, and pursue the further redemption of the great promises made by the founders in our Constitution. So let me now, without any more talk from me, turn over today's event to Professor Jack Balkin, the Knight Professor of Constitutional Law and the First Amendment at Yale, and Professor Reva Siegel, the Nicholas Katzenbach Professor of Law at Yale, the editors of this book, and the moderators of today's discussion. You all have information that was given out at the front desk with the full biographies, with the illustrious resumes for Jack and Reva and the other distinguished panelists, who will be introduced by Jack and Reva. So without more ado, I turn the discussion over to our wonderful scholars. Thank you very much.
So the first thing I wanted to do was to thank both the Open Society Institute and the American Constitution Society for their ongoing engagement with the 2020 project, and to also congratulate ACS on its new leadership in Caroline Fredrickson, and to thank the panelists who've come to join us today. In addition to Jack Balkin and myself, we have Walter Dellinger, who is the Douglas Maggs Professor of Law at Duke. Is that? Emeritus. And also, I wanted to get the dual identity, and also a partner at O'Melveny. And Mark Tushnet, who we give you a solo identity? Who is the William Nelson Cromwell Professor at the Harvard Law School. And they have a long-running association with questions of this book, which we're going to be giving you a little backdrop on today, and then beginning a conversation amongst us all on the panel. So I'm going to just start by telling you a little bit of history of how this book came to be, and the kind of questions it addresses, as sort of to get in view whatever we could be meaning by the Constitution in 2020. The project actually began when we learned about some documents of the Meese Justice Department of the Reagan years. And these documents were called the Constitution in 2000. And we learned about, some of us learned about these documents in the early 2000s. Others knew about them earlier. And what was the Constitution in 2000? The Constitution in 2000 was an effort to set forth an understanding about constitutional law that would guide both litigation and appointments for the Reagan administration in the 1980s. I think the documents are dated 1988. And these documents essentially set forth what the Department of Justice then saw as choices in interpretation of the Constitution, identifying lines of cases that they understood to be rightly and wrongly decided, and said that those who were concerned with matters of judicial philosophy, and particularly original meaning, would be concerned to preserve the rightly decided lines of cases and to resist as wrongly decided and political these other lines of cases. And the cases concerned matters which will sound familiar to you: separation of church and state, prayer, privacy, the contraception and abortion cases, issues of constitutional protections for criminal defendants, issues of race and equal protection, issues of federalism and the power of Congress to enact civil rights law, issues of executive power and takings. And essentially, these documents were setting out a blueprint for change in constitutional law, but presenting this as a process of working the Constitution pure or clean. And when some of us were learning about this in around 2000, 2003, what was truly the most riveting about the documents was that the law in the interim had bent to conform to the so-called rightly decided lines of cases and away from the so-called wrongly decided lines of cases. And seeing both the Constitution in 2000 documents and also the fruit of this work, some of us on the panel knew about it for longer than others of us. Nonetheless, it was just riveted the attention. It was a work of clarity, of intellectual power in a certain way, and it reflected a kind of nerve. So what did we do? Well, I think one of the things that struck a number of us was that at the time that we were, at least the some of us in the academy, were learning about this as opposed to the other of us in Washington who might have known about it, there was just some sense that there was a lot of criticizing of judgments of the court, but there wasn't a lot of effort to say affirmatively what the law rightly understood might be. And this project emerged out of the effort to engage in a grounded effort to state what our best understanding of the Constitution might be in a range of areas of law ourselves. We both had conferences in 2004, 2005. The second of them was a very large gathering, of which people here were there. And eventually this book emerged from this form of question asking and answering. And the idea of the Constitution in 2020 was an effort to, 2020 signified both clear vision and also the idea of a point in time ahead of us, but not so far away as to invite people to imagine a world completely other than the one they inhabited, one connected to the one they inhabited, but not in the grip of the is, as it were. There are something like 27 essays in the book, and there's now a website, constitution2020.org, and where some of the book is posted, and also where there's the beginnings of a blog. And both the conference and the book and these conversations are intended to free people from the pressure of the is, to have them step back and ask, really, what is the best understanding of law in a range of contexts? So one more thing that I would like to point out about the book and this exercise is that it's not the work of a bureaucracy. There's not a top-down picture of things. What the book represents, you'll see there are people disagreeing with each other in the book. We may be doing so on this panel. It reflects an effort of a number of people to make the best sense they could in dialogue with others, but it is understood as not a coalition effort, but a reflection of individuals who have at least common values enough to be in conversation with one another. So one of the key ideas of the book, I guess Jeff Rosen, in talking about the book in New York Times Magazine maybe 2 months ago, was focused on this idea of democratic constitutionalism that surfaces in the book. And it's actually a set of understandings which has different names throughout the book, but a very central understanding of those engaged in this project was that the Constitution is law, but it's also our law, that it's both it emerges from democratic self-governance, but tempered by values of the rule of law. And when we interpret the Constitution, we're making good on both of those dimensions of what our Constitution is. And this process of reflecting with one another about what the Constitution means, rightly understood, you'll see as we start talking about the project, really draws attention to the role of many constitutional interpreters. Not only the Supreme Court, whose membership we're, of course, in Washington today deeply concerned with, but also the work of members of the elected branches of government, not only in Washington but across the nation, as well as citizens who care about the way in which their law is enforced, both in the courts and in elected branches of government. And so in focusing on the questions today, we've sort of tried to actually, in an unconventional way, focus on pieces of this book, its concerns that have to do with the range of constitutional interpreters in our system. And we can point to many of the essays concerned with particular areas of law that have focused on this plurality of interpreters, and that's where we're going to start the conversation today.
Thank you. So here's how we're going to do this. We have 5 questions. They were carefully designed to pick out certain themes of the book, and I'm going to ask them, ask the panelists about them. See, it's sort of like Socratic method, only I hope more entertaining. The first one is about democratic constitutionalism. So Reva is correct. One of the themes that you'll see in a lot of the essays in the book is this idea of democratic constitutionalism, and there are sort of 2 major ideas in this concept. The first idea is that all 3 branches of government, the President, the Congress, and the courts, all play a role in enforcing our Constitution. Indeed, the states do as well, local governments do as well. Everybody plays a role in enforcing it. That's why it's democratic constitutionalism. The second idea is that when you focus just on the courts, you tend to miss this feature, and you also tend to miss the way in which court decisions actually emerge from interactions between social movements and political movements, the political branches, public opinion, and the judiciary. That is to say, if you focus obsessively on the courts, you actually miss most of what actually is going on when you understand how constitutional law is made. So the first question is going to be about that process. And I was going to ask Mark to start by giving us some examples about how you see dialogue between courts and political branches, social movements, political movements, public opinion, has guided the development of constitutional law in practice. There are many examples that you could probably draw from your work, but you just recently finished a book, 2 books actually. You're always writing a new book. One book is on the Second Amendment, and another book is on social rights. So whichever one you want to use as a beginner, just over.
Okay, I actually would like to talk about the second, the idea of social and economic rights as constitutional rights. And the reason I want to do that is that in contemporary U.S. constitutional doctrine, the idea of having constitutionalized social welfare rights and having those rights being judicially enforced, that idea just doesn't exist. And I don't want to suggest whether it should or not. What I do want to emphasize is that just put it in the sort of straightforward terms about contemporary debates, design of a national health care policy is a matter of constitutional significance, even if the courts have nothing to say about it. The design of a national education policy is a matter of constitutional significance. In other systems, these rights to education or to health care are to some degree judicially enforced. In the U.S., they're not robustly enforced, if at all. But the discussions that we as citizens and our representatives have about what we're going to do about health care are, as I will use the same phrase, are of constitutional significance. They communicate something fundamental about our self-understanding as a nation, and they can be as deeply embedded as anything in the written and judicially enforced Constitution. A relatively conservative scholar named Ernest Young has written an article called "The Constitution Outside the Constitution," and he enumerates things like healthcare policy, Medicare, voting rights statutes, and says, if you think about Social Security, is it more likely that there'll be fundamental changes in the Social Security system than that the provision dealing with the compensation of executive officials written into the Constitution will be amended? And I think the answer is no, it's not more likely. That we are committed to a form of social support for the elderly. And that's a commitment that is ours as a nation. Of course, we will alter and revise it as circumstances require, but it is constitutional in that sense. I'm going to just wrap up by stressing that nothing in this understanding requires significant judicial enforcement or participation. What it does require is sustained attention by we the people and our representatives to the kinds of things we want our country to be, and I think that's what the Constitution's about.
Okay, can you give me some examples of this back and forth between courts and the political process in shaping constitutional rights?
Well, Jack, the examples that are positive of where that dialogue occurred are 30 years, 40 years, 50 years old. I mean, they were the back and forth with the court in Brown announcing that the 14th Amendment means what it says when it comes to race, and laying down a marker to which the political branches had to respond given the clarion call of the court and the indigenous movement in the South that followed. Obviously, Congress and the president had to respond to those forces. It took a decade before the Civil Rights Acts of 1964 and Voting Rights Act of 65 were passed. I take your question about the role of other branches in the constitutional process in a different sense now, because to me the examples are all negative examples, by which I mean that I think a dominant, perhaps the dominant theme of the present court is that constitutionalism is exclusively a matter for the courts, and all constitutional questions are treated as if they were being decided by judges, with no sense of a role of the president or of the Congress in enacting constitutionalism to a really extraordinary degree. This really builds on Mark's statement that other branches should take account of the provisions of the Constitution that may not even be judicially enforceable. But where the Constitution is vested authority in the political branches, this court asks every question as if it were before the court. Not understanding, and I think Riva and Robert Post have written on Congress's power under Section 5 of the 14th Amendment, where the Constitution gave Congress the authority to determine what legislation is appropriate, and under the 15th Amendment. And now the court has abrogated to itself the exclusive authority to determine what is appropriate, and does so in assessing an act of Congress that creates rights good against the state. The court asks, would we have held this result in a lawsuit brought directly under the amendment? And if the answer is no, essentially Congress can't do it either, which utterly fails to recognize the institutional capacity of Congress. Take a hypothetical that we haven't seen fully ventilated, the 13th Amendment. It ends in voluntary servitude and gives Congress the power to enforce this amendment. Congress might well conclude that ending involuntary servitude, ending that system, means ending all of its vestiges of racism that went with it. And it would be a large basis for authority. Now, a court, I think, couldn't very well decide what actions by individuals constituted some sequela of involuntary servitude. I mean, the absence of judicial standards would make the 13th Amendment, outside of the area of actually forced labor, very difficult. But Congress, of course, as an institution, could make legislative decisions. But this court would invalidate anything that it would not have done as a court. Its disregard for other branches of the government reached its apogee in Bush versus Gore, where the court ignored the fact that the Constitution and federal statutes set up a whole process by which Congress would determine whether to accept contested electoral votes in the counting process. And it certainly comes through when the court has adopted standards under the 14th Amendment, when Congress legislates, asking whether the congressional legislation is proportionate or congruent. So I think we see negative examples of a complete lack of sense that Congress has its own institutional authority. Let me give you one last example. A bill that was passed and then repealed because Congress didn't want to defend it itself when we announced that we would not defend it in litigation. And that was a bill introduced by Congressman Bob Dornan that required the military to test every member for HIV and then to discharge within 60 days any person that tested positive without health benefits. Gone. And the question was this constitutional? If you ask whether the court would uphold it, the answer is almost certainly yes. That is, it may be vastly over-inclusive, vastly under-inclusive. It doesn't really advance military preparedness, but the court would defer to Congress's judgment. But why can't the president say, and we stopped short of the president announcing that he wouldn't enforce it, only that he wouldn't defend it. But in thinking back on that, why can't the president say, the constitutional rule is that a significant restraint on liberty that advances no public purpose is unconstitutional. Usually courts defer to the political branches. A district court would say, and the other courts after that, the political branches made this decision, this is an important in advance of the goal. But why do I have to do that? I can rely upon the chairman of the Joint Chiefs and the Secretary of Defense, both of whom think this harms our military preparedness military morale, it constitutes leaving our wounded behind. They think it hurts military. And if that's true, it's unconstitutional, whether or not a court could or would so hold. And so why can't a president say, I can make my own determination, and I can decide that this is a senseless, needless impairment of military personnel that doesn't advance a goal and therefore is constitutional, and I don't have to defer to a midnight amendment passed by Congress on a floor vote when I can call upon the resources of the government and make that policy choice. I think this court has utterly failed to understand that Congress and the president have the authority to do things that the court itself doesn't do, and that what we've seen is an absence, not a presence of institutional dialogue.
I was actually thinking when you gave the military example that, Brown doesn't spring full-blown from the head of Earl Warren. Brown comes out of political changes in the two parties and attitudes about race following the Second World War. It comes out of Truman's decision to desegregate the military. And indeed, basically, this is not a case where, in fact, Truman asked the court to overturn Plessy in 1950, and the court doesn't get around to it until 54. It seems to me that the history of a lot of the civil rights things that we now hold dear are situations in which the political branches got out there first and pushed hard first, and the courts came along later. I mean, the other example I was thinking of, I assume that might have been on your mind, is gay rights. This is a situation where constitutional argument made at the states and local level, was made in the political branches, came long before the Supreme Court finally decided to get in the act in Lawrence versus Texas. And if you want to give a conservative example of this is something that Reva's written about recently. I don't know how you guys feel about the Heller case, the Second Amendment case, but let me tell you, the Supreme Court decides that case when it does because there's been 40 years of social movement agitation for recognizing an individual right in self-defense. If there hadn't been those social movements making claims on the Constitution and supporting candidates who believed in that, then that would not have become the law of the land. And if you take that lesson seriously, the lesson that Lawrence teaches and Brown teaches and even Heller teaches, that suggests that the people who really have a say in what the Constitution means is the general public. And they really ought to stand up and make claims on the Constitution because ultimately it's their voices that will be heard over long periods of time. But, Reva, you've written a great deal about this in your work on social movements. Did you have something you wanted to add?
Well, I think that Walter had referred to work that Robert Post and I had done a couple of years ago on the power of Congress to enforce the Reconstruction Amendments. And because the court is once again rattling its saber, the Voting Rights Act and at Title VII most recently, it does seem that it's worth just going back and looking at that set of relationships, both because the law itself matters and also because it's exemplary of this larger problem with which the book is recurringly concerned. So one way of thinking about this is that courts and representative branches of government have just different characteristics. What we value, we prize in courts is their independence from immediate democratic lines of accountability. In part, I'm now drawing on work that Larry Sager also has done. So we prize in courts the notion of their independence, the fact that there aren't tight feedback loops between the decisions courts render and electoral reprisal, that judges have lifetime appointment and that they're appointed under certain kinds of circumstances, which is supposed to free them from that kind of direct response. On the other hand, when we're talking about the executive branch or we're talking about a legislature, we're talking about institutional bodies that acquire their legitimacy from their responsiveness to the electorate. And the genius of our system is that it entrusts the enforcement of the Constitution to different branches of government, all branches of government, and therefore brings to bear on the vindication of constitutional values institutional resources of these very differently constituted bodies of government. So we can see this role differentiation at work in the Reconstruction Amendments, which the 13th, 14th, and 15th Amendments have enforcement clauses that provide that Congress shall have the power to enforce the provisions of these articles by appropriate legislation. That is to say, each one of them vests in the Congress the power to enforce the individual liberties that the Reconstruction Amendments protect. And, if there's anything that the text of these amendments specify, it's that Congress is enforcing. The part about the courts enforcing is implied. It's very clear in the history of the amendments themselves, and it's deep in our tradition, but it's expressed in the text of the amendment that Congress is charged with this responsibility. So the Reconstruction Amendments become kind of constitutional puzzles, because if you acknowledge that there are multiple enforcers, you get a puzzle about how you coordinate courts and the representative branches of government. And one of the tools that have emerged that courts actually have developed are presumptions about constitutionality. And in the modern period, courts have worked out an approach to the scope of Congress's powers, enumerated powers, that generally takes since the cataclysms of the New Deal, the court has approached questions concerning the scope of Congress's powers with a degree of deference. The presumption that Congress has the powers that it's granted to act, and that there are mechanisms of accountability through the electoral process. And unless individual liberties are at stake, the court's going to approach restrictions on those powers with some deference, or so the presumptions used to be. And what has happened since the Rehnquist Court and beyond is that the courts have begun to summon the individual liberties powers to, enforcement powers of the courts to restrict Congress's powers. And so, sort of summoning the history of Brown's enforcement, the court has basically imposed restrictions on Congress's ability to enact the Violence Against Women Act, portions of the Americans with Disabilities Act, the Religious Freedoms Restoration Act, and made noises about Voting Rights Act and the Civil Rights Act of '64. And the book is deeply skeptical about this particular exercise of judicial review. And so one of the concerns here is the direction in which the court exercises its powers of review and when it intervenes in the political process. But the other thing that we're concerned about is just noticing that Constitution is enforced in different ways when political bodies that can deliberate on the scope of our healthcare system are in the process of enforcing the meaning of equal citizenship, and not only courts. So there's, I guess, two different examples, roles that we could point here. One is the kind of signaling function. Representative branches of government can tell Congress that civil rights matters in new ways. The courts, restate this again. There's a signaling function, and representative branches of government can tell or inform the courts that there may be new emerging understanding of our civil rights or civil liberties. And Jack's mentioning the gay rights example today provides an interesting illustration of that going on in states across the country, which we could spend some time talking about. The gun rights example might be another such example. And then there's also this notion that when a legislature goes to enforce constitutional guarantees, it can make good on them in different ways than a court will. If we're talking about guaranteeing freedom of choice, for example, what a legislature can do in ensuring that a woman who's making a decision whether to bring a child to term, what her resources and life prospects are, is something that a legislature has more resources to bring to bear on the puzzle. The Family and Medical Leave Act could be understood as an instance of guaranteeing freedom of choice in a form that no court is going to enforce, but which a legislature or Congress ultimately did.
So I hope you get a sense from these answers that when we're talking about democratic constitutionalism, we're talking about courts in a way that the conversation really hasn't been for the last generation. The conversation really has been focused on, well, let's get our people on the courts and let's let them decide things the way we want them to decide, and let's do things this way. And that's really not what this book is about. The book is about taking the broader picture and understanding how the Constitution actually changes over time and where our rights actually come from. I want to go back, though, to one question that was raised by Mark, and I just want to ask him very briefly to tell me, suppose somebody hears you talk about health care or about education or about other social welfare rights, and they say, well, that's all very well and good. You can talk about it like it's a constitutional right, but I don't really believe it's a constitutional right. I mean, it's just something that Congress is going to pass or not pass, right? He'll say, George Bush, he wanted to privatize Social Security. He didn't succeed, but he talked as if it was an ordinary statute, right? So the question that person might put to you would be this: what difference does it make that we think about health care or social safety nets or education as a constitutional right. How does it change the way we should do it in politics? How does it change the way that we would go about passing these programs? How does it change the way the executive should create regulations for these programs? And finally, how does it change the way that a court, which will inevitably get statutory claims, right, and administrative claims, should go about thinking about the program? What difference does it make?
Okay. The first thing I want to observe is that the objection that, or the framing the objection in terms of someone who doesn't think that that healthcare is a constitutional right is no different from framing the objection to Roe and Wade as, well, I don't see it in the Constitution. It's not a constitutional right. It's just something that legislatures could do if they want to. And so I don't think that the question about whether these are constitutional issues or not has anything to do with whether everybody agrees that there is a constitutional right at stake. I mean, you could play this out through campaign finance regulation or commercial speech regulation or whatever. So I think that's just that should be put to the side. The more serious question is, what are the consequences of understanding these issues to be constitutional issues? I think there are a couple that I'd want to emphasize. The first is that understanding them to be constitutional would or should alter the way we talk about them in our political discourse. And so it would be if we understood these issues to be constitutional issues, then we'd be talking about the best way to maximize the distribution of health care, rather than whether some people should have it and other people shouldn't. It's just a different framing of the question. Second, I suggested this earlier, if we understood these issues to be constitutional, they affect the way we understand ourselves as, the word has some connotations that I'm not entirely happy with, but citizens of the United States. What does it mean to be an American? Well, it means to have a commitment to, if we understand these issues to be constitutional issues, it means to have a commitment to ensuring that all Americans have access to adequate health care or live in a decent environment or whatever these issues are that are constitutionalized. And that would affect the way we conducted ourselves politically. And then finally, as you suggest, understanding these issues to be constitutional would give the statutes that we enact to embody these values a sort of special kind of normative weight. And so there's a strain in statutory interpretation that says what we ought to do is interpret statutes generously to promote their purposes. We don't do that with all statutes, but with these sort of Constitution implementing statutes, that's how how courts ought to approach it.
So I just go back to this general theme. If you start from the idea that we're going to look at constitutional law from the standpoint of the democratic constitution, lots of things start to look different. So Mark has just suggested how health care might look different. And Riva's work suggests how you might look at the way social movements behave differently. Here's another thing that might look different, and that's judicial review. So right now, as you know, so I see here we have the welcome to the overflow crowd from the Sotomayor hearings and the Michael Jackson funeral. But right now they're sitting, the senators are sitting and throwing questions at the candidate, asking, are you an umpire, and will you be completely emotionless in all of your judgments and things like that. And if you start from the proposition of democratic constitutionalism, all this just seems silly, because the question you want to ask is, how do courts integrate themselves in this larger process in which all three branches and the people themselves are constantly interpreting the Constitution, making claims on the Constitution? In other words, how do judges sit themselves in that role if you start from that proposition? That's what I wanted to start by asking Walter. Assume that we start from the idea that the president, for example, makes constitutional decisions all the time, and Congress makes constitutional decisions all the time, and state legislatures do, and citizens do. Now, suppose you just start there. Now, how does a court fit in that mosaic instead of thinking it the other way, which is what they're doing now over in the Senate, which is asking, please tell us what the Constitution means? How would we change the judicial review in two ways? First of all, what things would judges be more concerned to supervise and oversee, and what things would they be less concerned to supervise and oversee, or how would they oversee them?
The first thing you have to do is challenge the judge-centric view of constitutionalism that is completely dominant in the present court, and which to some degree has not been challenged by any of the members of the court. And that leads me to pose what I think is an extremely difficult strategic question when you think about the Constitution in 2020 for the Obama lawyers. Here's the question. To what extent, in arguing in a whole range of areas, cases representing the government or coming in as an amicus, to what degree do you accept the framework that has been created by the Rehnquist-Roberts court and make your arguments within that framework, which I think is the standard method by which the Solicitor General's office and others would appear, and which may give you the opportunity to try to find some way to marginally carve out and get a tiny victory by working within the court's framework and showing how this case can be decided in a progressive way, or however you want to put it. Or to what extent do you challenge that in the briefs, not accept it, not sit back? I think, for example, in Section 5 cases, where Congress has enacted legislation under its historic power, under the Civil War amendments, or in the voting rights area under the 15th Amendment, and you're defending that. Do you get into this niggling, is it proportional and congruent, and has Congress made the record? And what he said, you say, God darn it, Congress was given the power by the 14th Amendment to enforce this article and determine what was appropriate. I mean, the outer boundaries of that, there might be something inappropriate, but for the court to decide whether it thinks it was better for the Congress to reopen the coverage formula and re-stigmatize and open up that whole legislative mess, or use the historic formula, which is less stigmatizing, that's a judgment the court thinks it's going to make. I think that's just extraordinary. Another example is, do you accept in race cases the notion of racial symmetry that goes back to Croson, that no matter which way the discrimination runs, you ask the question logically exactly the same, what the court did in Louisville when it said that in Louisville and Seattle desegregation cases, that attempting to try to keep some racial balance in some of the schools was just like Jim Crow. Logically indistinguishable, total symmetry. When you ask, would you ever set aside a test because too many African Americans got promoted? And the government's in the process of arguing, yes, it works both ways, but this is crazy. I mean, the court has now created a doctrine under which a university that decided that it was going to take the top student in high school classes, and that's a good way to produce diversity, that would be valid only if it would also be valid for, say, the Texas Regents to say, we need new admission standards, facially neutral admission standards, to make sure that blacks never constitute more than 5% of our student body. We're getting too many. We want to get it under 5%. If you treat those as symmetrical, that they're either both valid or both invalid, you're accepting a framework that goes back to Croson and a framework under Congress's enforcement powers that goes back to Bernie versus city of Flores versus city of Bernie. When you accept those constructs, you're arguing within it. So to me, a question in each of these areas, like the undue burden in reproductive rights, rather than looking at an individual right the way we do under the First Amendment. We don't care that in the First Amendment, you say, well, most people can protest, so why can't we shut down the Nazis marching through Skokie? Most women can get an abortion under this rule if they want. Why worry about the ones left behind? In all of those areas, the tough challenge is whether, when you're litigating, do you work within the court's framework or do you challenge it? And I don't mean to suggest that's an easy question. I won 2 cases for the districts in North Carolina, the minority-majority districts, by showing that we could reach within the framework of Shaw versus Reno, invalidate those. And I'm not saying that's a bad choice, not to take on the underlying concept. But to me, that is a real challenge as you think about the Constitution in 2020. There may be some way to balance those. But I think the more we all write and argue, and you see lots of law review articles that say, would disparate impact, would it survive, completely accepting a symmetrical notion? Mm-hmm. This whole tension only arose when we went to a symmetrical notion between the parts of Title that was never in conflict before that. Do you write and argue and litigate within that framework exclusively? Because if you do, there's a sense in which it just gets to be the normative power of the actual, completely settled, that Congress has to pass through 19 hoops before that, each one checked off by the judiciary before it can carry out its historic enforcement powers. And that, to me, is really a question for the future.
Reva, can I just ask you, if we start with democratic constitutionalism, if that's our postulate, how does judicial review look different?
Well, I think that there are clear ways in which parties across the political spectrum, by parties I mean persons across the political spectrum, sort of have a different picture of who courts are there to protect and why they're needed and who's at risk in the system. I think that what you're hearing in Walter's passionate remarks is the fruit of many decades of reflection on what are the respective roles of the courts and the political branches, and bodies of law that grew up on the understanding that there was a large role for our political branches, that is to say for representative branches of government, to play in enforcing civil rights, and the role of the courts there was to defer to the political branches when they were in the civil rights enforcing mode. The reason for having energetic judicial oversight is when the individual was at risk of being the object of certain kinds of group-based prejudice. And what you're seeing in the turn of our Section 5 law, or sort of this questions raised about Civil Rights Act and Voting Rights Act, is the unholy commingling of those two lines of cases, so that the court, in an effort to cut back on the scope of Congress's power to protect civil rights, is using precedents, a role that was worked out to protect the individuals, such as the individual plaintiffs in Brown or the plaintiffs in the Loving case involving miscegenation laws, that the powers of review that were designed to protect the individuals against the overreaching state are now being used to restrict Congress's power to enact civil rights laws protecting those same individuals. And it's not an accident. It was a form of retreat that was worked out by, I guess, members of a bench concerned to shift the law in a way that wouldn't too greatly distress the American people or too greatly alienate them. And you can see the beginnings of this in the Constitution in 2000 documents that I was talking about at the very beginning of the hour. I believe that many of the people writing in this book actually disagree about the extent to which there's a special role for courts in the system. I see a special role for courts, and a number of people still see a special role for courts, for the very purpose of protecting relatively disempowered individuals against large mobilized majorities, and also by reflecting back our values in a form that political branches themselves can think twice about. What do I mean by the second? Something like that judicial review, and I think in the sort of account of democratic constitutionalism here, which sees the Constitution as emerging, dialogically in this way, sees a role for courts in asking mobilized majorities to think twice about what really mattered to them. That there's a limit to the way in which courts can ultimately break what it is that the American public decides to do, but it can ask it to reflect in deep and considered ways, and that's exactly why we have the institutionally differentiated forms of government we do, and it was a deep and revered piece of work that the court did around issues of racial justice in the second half of the 20th century, and no one in a position of legitimacy today in the public debate is prepared to repudiate that history. Those who want to slow down the courts are actually trying to ride on to claim the mantle of that kind of history. They're using its language and they're claiming its memory for new ends. But I think it requires us to speak out and say this is a misuse of what courts are there for, and to redirect the courts in some of the ways that authors in the book do here.
So we've been talking about democratic constitutionalism as a new way to think about courts, a new way to think about the ability of everybody in the political system to make claims on the Constitution. If you look at the last 2 decades, though, what you'll see is that you've gotten a series of slogans about legislating from the bench, and especially originalism as a way for judges to do what they do. Now, I should just tell you, I myself am an originalist, and I don't recognize what the courts have been doing for the past 2 decades as being originalism of any sort that I would claim. But that's a different debate. We can talk about it maybe at question time. What I want to ask Mark, though, is the following. Although, in fact, political conservatism has been rallying under the banner of originalism, original understanding, original intention, later original meaning, is that actually what the conservative majority on the Supreme Court has actually been doing? What exactly have they been doing? And what's a better way to do it, I guess, would be the question. It's a question about interpretation.
I think that the straightforward answer is, as you suggested, that originalism was developed as a useful organizing technique to mobilize political conservatives around a set of substantive goals that they sought to achieve, or substantive criticisms of decisions that they disagreed with, but that it was, I would suggest, never the comprehensive program for interpretation. It was a critical device to get at some things that conservatives didn't like. When they wanted to do things that could not be reconciled with original understanding, original meaning, or whatever, then they just ignored it. The symmetry decision, the Seattle school case, there's not a word about what happened in 1867 or 1868, which you would think would be the relevant thing for original. I mean, literally not a word. It's all about what Brown meant, as if Brown was about the original understanding of the 14th Amendment, which it wasn't. So if they have a goal, they'll do what actually judges do all the time, which is use whatever techniques are available. So again, in the Seattle school case, you have this precedent, Brown. There are various ways of reading it. You read it in one way, your opponents read it in another way, and you come to some conclusion. There are just a bunch of ways of doing things. Conservative judges have not been originalists consistently. They've been conservatives consistently.
There's a really if you looked over the decades, you'd see in the 70s Raoul Berger would treat Brown as inconsistent with original understanding. And then when it was no longer feasible to attack Brown, it turned out they started to use civil rights language to attack Brown, and so wrapped themselves around the language of colorblindness. And so you get this idea of parallelism at the point at which the legal systems and the legal questions in the system had shifted. And now Justice Scalia will claim originalism as his exclusive method, but in a case like Parents Involved, all that any of the justices are doing is arguing over the meaning of Brown. They don't go back to the 19th century. And you could say, well, Roberts wrote that opinion and Scalia didn't write that opinion. But when Scalia came in the Ricci case to rattle his sword about, what does he say, that evil day, when we reached the question of the constitutionality of disparate impact law, he didn't talk about any foundation and original understanding for anything he was suggesting there. It was just he didn't like it. So the question is, how is it that you get a practice of judging? It claims it's emanating from a method, but the method is inconsistently adhered to, and therefore you get to the result that Mark was suggesting, which is that there's a blueprint for change which is associated with a method, but in fact represents a substantive vision of the good, which they're entitled to have, but it's not a method.
Rivas mentioned this Justice Scalia's evil day line, and in the Ricci case, and I can't resist. I sort of feel like saying, like Fezzik in The Princess Bride, I don't think the word means what he thinks it means. Right?
If you did anything, Attorney General Meese's vision of originalism and those who promoted it in the early administration was really confined to the Constitution of 1787 and 1791, the Constitution and the Bill of Rights, and they did it without seriously reading the debates. So they just assumed that a bunch of affluent white males, many of them holding slaves, whatever they intended, they would be comfortable with that. And that was a good reason to go back to their specific intent. If they read it, they would see that the framers actually fully contemplated unenumerated rights at major points in the discussion of the Constitutional Convention. And they never went to originalism on the 14th Amendment. And you won't today. You find discussions of original understanding of what was debated by the framers almost totally absent from conservative decisions under the 14th Amendment, because it is so clear that the framers intended to give Congress, and to a lesser degree the courts, broad powers to determine what are the liberties. They rejected the idea of including a specific list of liberties. Now, there are some good arguments against giving national courts this fairly broad power to set aside state rules. Mm-hmm. But they are arguments of policy. They're not bad arguments. They're arguments of policy. They have almost nothing to do with the text or the original understanding of the Reconstruction Congress. And they only get to that by trying to limit the scope of liberty by saying, well, did the framers actually specifically contemplate abortion? And there's a very simple answer to that. And like Jack, I believe I'm an originalist. Suppose my grandmother on her deathbed, when I'm heading off to college, says, I want to give you $500, but I want you to promise that you'll abide by my intent, which is that you use this money to buy nutritious food while you're in college. I'm really worried. I said, Grandma, my promise. Okay. And I get to college and I want to do that. How do I go about deciding what she meant by nutritious food? You know, a true non-originalist would play games and say a heavy work of philosophy that you want to buy as food for thought or something. But no, you really want to be true to her intent. Some of the conservative restraints in cases like Roe and Griswold say, well, you would essentially go back and find out what she actually ate, when she was a girl. And that would be what was nutritious. Instead of going to the Harvard Public Health School and trying to read up on nutrition, you'd go back and look at that, as if that's what she did. Or you would look at, did she say things in her diary like, eat fat back twice a day, it greases up the veins and is good for you? Is that what your grandmother, or did she intend for you to exercise your best conscientious good faith judgment about what is nutritious? And that, I think, is where the debate over originalism lies, that even though there's very good evidence that the notions of what constituted the essence of liberty or cruel and unusual punishment were to be addressed to our best sense of the day, our notions of equality would expand to include not just African Americans who are originally intended to protect, but then women and gays and our sensibility. And the idea that that's not what was intended or is contrary is just a case that has not been proven. And so I think a true originalist would see that.
Great. I think it's time to open up for questions. Any questions on either democratic constitutionalism or the eating habits of Walter's grandmother would be appreciated. Yes, sir. Yes, sir. And just, if you could just take the microphone and introduce yourself, and that would be great.
I'm Paul. Hello? Hey, I'm Paul Ramshaw. I'm at the EEOC. What's the relationship between democratic constitutionalism, if any, and campaign finance reform? Because one of the campaign finance reform, it dictates whether Congress says what the people want.
Good. You want to take that one? All right. Well, I mean, I'll give you a very simple beginning answer, and I'm sure everyone else will join in. Think about it this way. You might ask yourself, do the American people think that contributions should be treated the same way as other forms of speech? That is to say, do they understand political contributions to be more like voting, right? Where I can't buy your vote, and I can't, if I have a lot of money, get 5 votes or 10 votes. Or do they understand it to be more like expenditures on bread, for example, something like that? I think what you find is, in the United States, an enormous concern about the degree to which our political system has become corrupted over time. It's become corrupted by the influence of money. And I think that the reason why, in fact, we have campaign finance regulation in the United States is because, in fact, a lot of Americans think that it's actually central to preserving the Republican form of government that the Constitution guarantees in Article 4. Now, this is completely different from the question of what's the best way to organize a system of campaign finance that might, in fact, prevent undue corruption in our system. And we can have a policy debate about that. But those decisions about how best to structure it, those aren't necessarily decisions that a court would necessarily make. The basic job for a court here is to understand how does political expression in a campaign setting integrate with democracy, with the democratic system. That's the constitutional question. It is, I should tell you, though, that although that's how I see it, it's not clear to me at all, by the way, that the current majority on the Supreme Court sees it the same way I do. In fact, they just asked for briefing on the question of whether or not to strike down the whole kit and caboodle under the First Amendment. And essentially, there's some talk that they may even change the rules regarding corporate contributions and labor union contributions, which have been in place since 1907. But others would know more about this than I do.
Campaign finance raises, to me, the compelling fact that judicial activism is now what is being sought by political and constitutional conservatives overwhelmingly. I mean, there's still remnants, a lot of them, in the Senate Judiciary Committee hearings of critics of Judge Sotomayor saying we want to make sure we don't have any judicial activist on the court. But if you look at the principal issues of the present day that are on the conservative list, there are a couple, abortion and perhaps, gay marriage litigation. But they're almost all issues where conservatives want courts to use fairly vague or ambiguous provisions of the Constitution to strike down laws enacted by the people's representatives in the National Congress, the state legislature, and local government. Look at the half dozen that would come to mind. Campaign finance regulation, where they would like to see acts of Congress struck down, in my view, in that case, correctly so. Kelo, the takings for public purposes, where they want judges to say that towns are wrong about what constitutes a public purpose. And again, there's something to that. Reverse discrimination case, where they want to set aside what local governments are doing, and perhaps set aside what Congress did in Title VII. in the area of voting rights, where they want to set aside what Congress did, and perhaps in the area of economic regulation, depending on what comes out of this economic crisis. So in all of these areas, we're looking at a future between now and 2020, where the issue is going to be, are the courts used in an activist way to accomplish this agenda? So first, see, someone will say, this is a parody, but it's really, I think, gets to the heart of it. I want to make sure you're not a judicial activist. And then I want to make sure that you will strike down gun laws, strike down this law, strike down voting rights. That's what the agenda seems to be.
I just wanted to say that in many of these cases, there was some paradigmatic scene where we came as a nation to have concern about gross inequality of power, the individual against the state. So the court acquired, in the modern era, authority to enforce the First Amendment by striking down political enactments of state governments. And the question is that kind of power of review appropriately directed against campaign finance legislation where it's not clear how to solve a problem and there's good faith efforts on the part of the political branch to make sense of a set of constitutional values. And I think the same is true if we revisit the reverse discrimination cases. You'll see that there was a scene where we had reason to be worried about the way in which politics was working out, and that's being tapped in cases where at least many would say that the political branches are deliberating in full consciousness of constitutional commitments and trying to make good on them, and it's not necessarily clear that there should be this kind of managerial oversight, disrespect, and whatever for the competence of politics to engage in a question.
Bill Taylor has something to say
Yes.
on that.
Is there
Have mine. Oh, they're right behind there.
My name is Bill Taylor. I'm a civil rights lawyer. On the question of what special role, if any, the courts have, it has struck me, one of my favorite footnotes, maybe yours too, was Caroline Products, which talked about the discrete and insular minorities and the special role that courts have in examining the claims of people who cannot get a hearing in the other branches of government. Now that's become a more complicated question, I think, as some of the things that you've said indicate. For example, it's been suggested that because there is concern in the United States Congress about the votes of minorities who now have been enfranchised to a degree, that African Americans and Latinos are no longer discrete and insular minorities. So the question, I think, is what continuing, and I've also thought that maybe the Caroline Products footnote is a legal way of expressing the question of empathy that the courts might give. But what's the continuing role? I mean, the courts have gone to great trouble in a different era of trying to examine the differing levels of scrutiny to be given to the claims of different groups. Is that a workable concept in the future and in 2020? I mean, the most stark differences are now between the people who are clearly advantaged and people who are clearly disadvantaged, which, as Marx suggests, is not where the Constitution seems to be going right now in examining economic and social claims. So what do you see as you look into the future?
Mark, can I just ask you, Justice Marshall talked about this in 1970. He didn't think that the current structure made any sense then. Has anything gotten any better since?
I don't know. Yes, things are better now. I was think about what's been accomplished with respect to disability rights and gay rights. Mostly in both of those areas through statutory developments by the people mobilizing to get their representatives to do the right thing. I want to pick up on a theme from Bill Taylor's comments and I think suggested by Walter Dellinger which is this. I'm going to end up being pretty provocative, I hope. I've been a skeptic about judicial review for my entire academic career. One thing about this judicial activism stuff is imagine the following scenario in 2020. The Obama administration is a tremendous success. The climate change legislation is adopted and it works, and healthcare financing is adopted and it works, and Democrats are elected to the presidency in 2012 and 2016 and have substantial control. Did I get the dates right? No. And have substantial control of Congress, of both houses of Congress. And what's happened to the Supreme Court? Walter tells me that Justice Scalia in 2020 will be 83 years old. The oldest of the present conservatives would be 83, younger than Justice Stevens is now. Now, we've experienced this before. It was called 1937. And we might want to be thinking now about how we progressives are going to deal with a world in which the courts are regularly serving as obstacles to the accomplishment of what the people of the United States have, through the course of several elections, decided to want to do. So my provocation is it's Franklin Roosevelt's. The number 9 is not written into the relevant portions of the Constitution.
By the way, Mark, my understanding is that actually turned out well. That is to say, my understanding of the history is a little different from yours. It's that you had resistance from a conservative court. Eventually what happens is people retired and were replaced by other people. And it was precisely because of the resistance you got from the conservative court that you actually got a much more progressive system of governance. And so it's not immediately clear to me that we're looking at it. Well, if we are, it's a replay of 37. I'd be happy to take that over again. But the other thing is you might think, well, one way to do it is to is to do nothing. Another way to do it is to say expand the number of seats, which I actually don't support. Another way is to promote the idea of term limits for the Supreme Court justices, which I do support, and which people on both the left and the right support. That would also have the salutary effect of enacting in a different way the basic principle of democratic constitutionalism by continually rotating in office the people who serve in the nation's highest court. I don't know what your view on any of that is, since you yourself are a skeptic of judicial review, but I thought that's another way of thinking about it.
I would just like to weigh in. I had indicated before that I thought that whether it's on interpretation or on the role of courts, that there are in fact more than one voice in this book, and there's more than one view on this panel. And there are, one could just take the view that given who's on the courts and given their underperformance, we may as well do without them. I don't particularly take that view, although I think what we underappreciate is the respectable and respect-worthy role of our political branches in making good on our constitutional commitments. I think we need to think about that clearly. It involves questions of confidence and role morality and responsibility, which we ought to be talking about in many, many settings. So Mark and I would completely agree on that front. Yet I also think that there's, I indicated before, I think that there's an important role that courts can serve even if our Constitution is enforced through the political branches. And that is that as a people in our history, we do better and worse by our own commitments, and that there are moments, there are matters about which we can look and see that we really screwed up and treated people badly, and that we, remember in the negative sense as wrongs we engaged in as a people that we want to avoid. And courts have played a role in our thinking twice about what we're doing. And if you look at even the question of the status of gays today, It's in part because there's both a story of legislative constitutionalism there, that if you look across the nation in localities and states, you'll see matters deliberated through political bodies that enacted new norms that are filtering their way into our national consciousness. But there's also a story here about courts having, at the state level, stepped in and called into question restrictions on the institution of marriage that have begun to alter the national conversation and alter our background meanings. And that's a story that we saw played around issues of gender, around issues of race. It's a great story. It's a story that is this dialogic, collaborative story in which courts, because they're relatively insulated, sometimes can hear and say, let's stop and think about this twice, whether this is really consistent with our best understanding and our commitments. And when they've done that, they've created a space for people to, in politics, say to one another. They've empowered certain voices otherwise not heard in politics to say, there's a role, there's a place for revisiting our best understanding of the equal protection of the laws, or what are the unenumerated liberties that this society protects. And because this is an important part of our history, we really ought to be looking not only at what it is the political branches need to be doing in enforcing the Constitution, but at accreted bodies of doctrine, which are the outworking of political mobilizations to take the courts, which don't serve the best understanding of the document as we understand them and might misguide courts in the use of judicial review. And those, I think, Walter was enumerating whole ranges of areas now in which in the past 20 years a conservative judiciary has built doctrine so as to authorize judicial intervention in politics in ways that don't accord with this understanding of Caroline products. You know, there's a difference between using the courts to interfere with the political process to protect the interests of a discrete and insular minority and to oversee anything having to do with race generically, right, which is the symmetrical doctrine that we're now looking at.
I think if I'd been a judge, I think the hardest question for me over and over again would have been, what is the proper role of judicial restraint? That is, I think it would be, I could come to a conclusion about any constitutional issue. Do I think that private development is a public use for purposes of the Fifth Amendment? You know, maybe no, but states seem to think otherwise. What is the proper gap between what I think when I look at a constitutional provision and what Congress or the President or the states have done? I think it would be very, very hard, and one would want to be, you know, consistent across the board about that gap. And the last justice I knew that really was cognizant of that was John Marshall Harlan, who would make up his mind about what he thought and then think, but is it clear enough that I should set aside what others have done?
I'm just going to throw one thing in. This really has to do with empathy, okay? The way that right now this is we see this conversation taking place on the court is when in questions of equal protection law, you have a minority complainant saying that this use of the criminal law or this act of national security has harmed me. The courts now are saying we defer to democratic processes. But when there's a case like the Ricci case or an affirmative action case, suddenly the court says we have the authority to intervene. And so there really are deep questions about when this power of oversight is being exercised. And if there's some deep point of disagreement here, it really has to do with exactly the question Walter's serving up on what occasion.
To tie this back to where Jack began, into a theme that Mark has articulated really throughout his professional career, this notion of other branches as constitutional actors. One of the problems of our judicial focus is that we assume that the judiciary has taken care of a problem, and we therefore do not give it the intensity of our political consideration that we should. Take the example of the criminal justice system. We assume that they're federal judges, they hear habeas cases, they look at search and seizure issues, they do look sometimes at conditions of confinement. They're taking care of that, right? Maybe not as well as we would think. But if you step back, there's this enormous problem, I think, of really constitutional or at least fundamental division. We are incarcerating this enormous proportion of the African American male population under a system where we have set up, where we decriminalize one half of the transaction virtually, that is use, and enhance the criminalization of the other side. We enhance criminalization of the supply side and decriminalize the demand side, making it clear that we don't think the criminal process should be used to affect all the affluent people that buy drugs, but to incarcerate the other half. I mean, this is to be a fundamental thing, that only one half of the drug transaction is subject to criminalization. It's actually the less deterrable part, and in some ways the less culpable part than those who are choosing to pay their money to hire 14-year-olds to do this and putting them in juvenile detention. This is an enormous problem, and I think because we think of judicial review and that prisoners have and defendants have cases, that someone is looking at this enormous systemic, deep moral wound in our society, that we've done something that I think when we look back in horror, we think, why were we all talking about, a takings case or this or that, when this enormous proportion of our population was being incarcerated under a system that didn't seem to make sense when you looked at the other uses of the criminal process. And in some ways, judicial review makes us stand back when we think about rights and assume it's not what we have to actualize as a political movement.
Let's take another question. In the back, sir. Yes? Yes.
Hello, I'm James Wright. I'm a writer for a paper here called the Afro-American Newspaper. And I guess as a black male, I'm supposed to be concerned about such things as civil rights and affirmative action and voting rights, and I am. But let me say what really, really concerns me is the expansion of presidential power. You all know about a case that the Supreme Court looked at in terms of whether the president can determine an enemy combatant as a terrorist. Here's why that scares me. If the president has that type of power to determine if a citizen is an enemy combatant, and you can correct me on particulars, how does that look for someone like me who is a Democrat when you have let's say, a Republican president? And also this issue of privacy, I am really concerned about America's eroding lack of privacy. What will the Constitution look like in 2020 in terms of those two issues?
Well, I'd like to talk about that because those are things I care about a lot myself. It's a long subject. Let me start with surveillance, and let me tell you a sad story. The sad story is the way we designed our system was that Congress would oversee how the executive branch dealt with intelligence surveillance. And it turns out that system didn't work very well. You see it in the papers every day. There were just stories recently about it. The problem is this. We have entrusted the executive branch with the duty of keeping our country safe by building out intelligence systems, more and more sophisticated intelligence systems. What we haven't done is we haven't put together the checks and balances within the executive branch to make sure that there are audit trails, and when somebody is watching you, somebody is watching them, watching you. All right? That's what we didn't do. We did it in a limited way in what's called minimization requirements in FISA, but we could do so much more. And I think it's very important for the public, including people like you and me, to basically say to Congress and the President, you have to redesign your systems. You have to make them more accountable. You have to, even if some things can't be made accountable, known to the public, you have to make them accountable within the executive branch. This is a great constitutional demand, and it's one that the courts are going to play a relatively small role in. Congress plays a role in designing structures, and the executive plays a role in carrying them out. And this is something that in fact, this administration could do, because it's been given, here unfortunately I have to say it, a blank check by Congress in the FISA Amendments Act of 2008, which revolutionized the way in which foreign intelligence surveillance is conducted and gave a great deal of new discretion to the executive branch. But it's an opportunity that, if this administration takes it, could actually redound to the benefit of civil liberties. As to the other point you made about rounding up enemy combatants, I think, in fact, the Supreme Court has done some good, because what they did in the Hamdi decision in 2004 is to say that when a citizen is apprehended, a citizen has to be given due process. But the degree of protection that they gave citizens is relatively weak. That is to say, it's not everything that one needs. And here again, the executive branch working with Congress really are going to be the first line of defense in protecting our civil liberties. We have to reform the really outrageous Military Commissions Act of 2006, an act which, in fact, parts of it were struck down by the Supreme Court, you may know, but other parts, courts are never going to look at. And so the real decisions that have to be made are decisions that are going to have to be made by Congress and the President. The real question is whether or not there'll be political will for this administration to make those necessary reforms. But they won't have the political will unless citizens like yourself and myself say to them, this is something we really care about, this is something that should be on your agenda, this is something that we should do about because the Constitution requires it. One more question. You have something you want to say on that?
This raises I think it's an excellent question. It raises the enormously hard issue about to what extent should we look backward and hold people accountable for what were violations of U.S. laws on torture and foreign intelligence surveillance, blatant, secret violations in these areas. And I understand the notion that the best argument against continuing to these investigations is that Bush ruined America for 2 terms. Why should we let him ruin a 3rd term, right? And dominate this term? And that's, I understand the force of that in the sense. But it's a very pivotal moment if we think that. What troubles me, and I do understand that enacting health care is probably far more important in many ways than tracking down some miscreant that knowingly violated the FISA law. And I understand that, but the problem is, it seems to me that that's importing a political consideration into prosecutorial decisions, which is exactly what we think went wrong. It may be a good political reason, but it's a politicization of what would be the ordinary process of the criminal law to short circuit. And I'm still struggling about mine with this. I think the answer may inhere in the fact that you proceed to investigate everything in the normal way where you have credible evidence that a law was violated. And at the end of the day, if there's to be some abatement of prosecutions for this kind of reason of civil peace, it should be done by the president, publicly, visibly, transparently, after everything is known, like Carter's amnesty for Vietnam War draft avoiders who went to Canada. I mean, but that it shouldn't come in and infect the decisions of the Department of Justice as it proceeds to look at these allegations of criminal conduct.
I'm afraid we're out of time, but I wanted to thank the Open Society Institute and the American Constitution Society for sponsoring this panel. I wanted to thank the panelists for a really excellent discussion, and I'd like to thank you all for attending. Thank you very much.